This is case number 21-166061. This is Cash LLC versus John Cozy. Matters before the court set on for hearing on a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Keith Sparks on behalf of the plaintiff.
Your P number, if you will, Mr. Sparks.
Sorry, P77485.
All right, thank you. Good morning to you.
Good morning.
The defendant in this matter, John Cozy, your appearance at this time, please.
John Finn, appearing on behalf of John Cozy. My P number is P33678.
All right, thank you, Mr. Finn, and good morning to you as well, sir. All right, so I take it that you guys have perhaps talked about this a little bit, but it looks like the motion sounds in a claim that there is no genuine issue of material fact, given the fact that the plaintiff is suing on a promissory note. Somebody talk to me and update me at this point. The plaintiff.
Yes, the parties have wanted to engage in settlement negotiations, but it's my understanding that the defendant is unable to be reached.
That would be true, Your Honor. I've called and left 5 or 6 messages at his house. I've also written him a letter. Have not been able to reach my client. I don't know what his status is. I'm assuming he may be in the hospital or something like that, but I really cannot speak on his behalf at this point. You know, we are where we are.
All right, and I think this came up last time, if I recall, Mr. Fan, the last time you indicated to me that you were not able to reach your client. Is that correct, sir?
That is correct, Your Honor. And we did kick this over for another 30 days and gave me another shot. And I haven't been able to reach him this time either.
All right, sir. Mr. Sparks?
You know, as far as how the court wants to proceed, you know, I'm fine with going forward with the motion. I'm fine with giving him another chance to try to reach him. I don't know if that sounds like it would be successful, but you know, I'm open to whatever the court wishes to do.
Thank you, Mr. Finn. Anything further at this time, sir?
You know, I have, you know, like I said, I've called him and left messages 5 or 6 times. His phone is still hooked up, and I'm still, you know, it's still ringing, and I'm putting on a voicemail. And I'm leaving messages, and I wrote to his last known address. I don't know, you know, I don't want to waste the court's time. But on the other hand, you know, Mr. Cash or Mr. Cozy may be, like I said, he may be in the hospital. I don't know what's going on.
You've not been able to file a response with Mr. Cozy's involvement as it relates to the motion for summary disposition, correct, sir?
That would be correct, Your Honor, because I don't know. As I remember it, I do not, he did not have a defense, but he did want to talk to them about, you know, a lump sum payment and that sort of thing. And I can't even talk to him about that.
Gotcha. All right, the court at this time will determine that there is no genuine issue of material fact and that the plaintiff is entitled to judgment by summary disposition as phrased in the motion. I will delay entry of the motion, strike that. I will delay entry of the order for 2 weeks. That will give any space in which there might be some information brought to bear with the court, something in the nature of a emergency motion or notification to the plaintiff, and that these issues can easily be brought before me. But if none of those kinds of things occur, I will sign the order upon presentment to the court after the expiration of 14 days. And is on the terms as prayed in the complaint. So you can submit the order. You can submit the order right away, counsel. The entry will be entry on the order will be delayed until the 14th of July. And if I hear nothing further, then I'll simply enter the order at that time and return to. The email address where you can send that order is Latifah, LATIFAH .Hunter. That's at 36districtcourt.org.
All right, I'll have that file or emailed right away, Your Honor.
All right, thank you. Thank you. Good day to the two of you.
Thank you, Your Honor. Thank you, Mr. Finn.
Bye-bye.
The court now calls case number 21-167844. This is GTV Networks Incorporated versus Suburban Mobility Authority for Regional Transportation Smart. Today is a time set for a pretrial conference regarding this matter. Your appearance for GTV Networks.
Your Honor, I don't think I've seen anyone for GTV Networks appear yet.
Your appearance at this time, Madam Counsel.
Good morning, Your Honor. Andrea Malinowski, P82842, appearing on behalf of Defendant Smart.
Thank you, Ms. Malinowski. Good morning to you. This case was last here. Well, actually, I just signed an order on the 27th of June for a protective order regarding the video in this matter. So give me an update if there's ones that can be had. Have you spoken with the other side recently?
I have not, Your Honor. This is actually the second conference that we've had where they failed to appear. We also did file a motion for summary disposition, which you'd previously indicated that we could set for hearing today. And we did do that. And that motion was also served on plaintiff back on June 8th. And they failed to file any response to that motion as well. So that's kind of where we're at right now.
Thank you, counsel. And I do see, I'm looking at the court scheduling order, which did allow for the filing of motions dispositive and otherwise, so long as there was at least 10 days opportunity to respond. Counsel has indicated that she filed the motion earlier in the month, about June the 9th. I don't see where it is. Hold on one second. Let me hear some. Yeah, I did in fact receive the motion, and I have not received a response to the motion, and the motion indeed has been timely filed and submitted to the court. So counsel, I don't know why the other side is not here. I know that the court gave proper notice with regard to this date. And as you indicated on the previous occasion, no one appeared at that time, and I set it over. Your pleasure at this time, Madam Counsel.
Your Honor, at this time, we would just ask that, I feel like at this point, the case should be dismissed with prejudice. They didn't file any type of response to our motion for summary disposition. So they failed to produce any evidence to dispute that. And this is the second conference they've failed to appear at, so.
All right, in regard to the motion for summary disposition, the court will grant the motion finding that there does not appear to be a genuine issue of material fact, and that plaintiff is entitled to judgment accordingly in this matter. The case accordingly will be dismissed. I will leave open the issue of dismissal with prejudice. The plaintiff certainly has the right and opportunity to file a motion explaining why the situation is where it is at this point. But the motion for summary disposition is granted. There was no response to the motion, and the motion was timely filed, and the motion made clear that the defendant's desire herein was that the case be dismissed where there is a failure of a genuine issue of material fact, and the court has granted the motion on that basis. And counsel, you may submit your order, and I'll sign the same.
Okay, thank you, Judge.
court now calls case number 21-169-332. This is Synchrony Bank versus Deborah Brown. The matter is before the court, set on for a pretrial. Your appearance at this time for the Synchrony Bank.
Good morning, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P61828, appearing on behalf of the plaintiff. Thank you.
Thank you, Mr. Canine. Good morning to you, sir. For defendant Deborah Brown, your appearance at this time.
Yeah, good morning, Your Honor. Trevor Stratton, P65124, on behalf of the defendant.
All right, thank you, Mr. Stratton, and good morning to you as well. Somebody update me regarding this matter. Do see. One second. You got a lot of background noise in the background, Mr. Stratton. All right. Now, Mr. Canine, update me on where things are.
Your Honor, we
I went ahead and muted you, Mr. Stratton, and you can star six and come back in. You got a lot of noise in your background, so that's why I muted you. I'm going to hear from Mr. Canine to try to update me on this matter at this point. Go ahead, sir.
we did have some settlement discussions, Your Honor, but we were not able to resolve the matter. But I would say those were some time ago. We've not had a recent conversation. So that's where we stand. We really didn't do any discovery because we don't, at least plaintiff doesn't need any discovery. So
All right, thank you,
I
counsel.
think I'd probably, to answer your question, Your Honor, I think I would benefit from a brief conversation with Mr. Stratton this morning. Thank you.
Right. That's what after hearing, that's what it sounded like you were saying. So, Mr. Stratton, I'm going to put you and Mr. Canine in a breakout room and give you opportunity to discuss this case and see where everything is, and then you can come back in and I'll get right back to your matter. So, Mr. Stratton, I'm sending you a notice for breakout room 1, and I'm sending Mr. Canine that notice as well, and I'll see you all on the other side.
Okay. Thank you, Your Honor.
Yes, sir. The court is calling case number 16-107876. This is Baker College versus Siobhan Cooper, also known as Siobhan Trust, TRUSS. The matter is before the court on a motion to set aside the payment agreement. Your appearance for the plaintiff, Baker College, please.
For the record, Your Honor, Stuart Collis, P49530, on behalf of the plaintiff.
All right, thank you, counsel, and good morning to you. For defendant Cooper Trust, please.
Good morning, Your Honor. Katrina Ferrugia, P70480, on behalf of Ms. Cooper. Your Honor, this is a motion.
Thank you, counsel, and good morning to you. I see that this is a motion to vacate the order, setting aside the order for installment payments. Counsel, you may proceed to tell me what that is about and what you're asking the court to do. Go right ahead, ma'am.
Very good, Your Honor. Essentially, the court rule seems to provide 14 days if you object to a motion to set aside installment payments. My client in pro per attempted to do that. I did attach that as Exhibit A. And the order setting aside the installment payment was entered over her objection without a hearing. She did attempt to make payments. She was making payments through Mr. Collis's firm's website. She didn't know that that was not an acceptable way. She made 2 payments, one in September, one in October. She was then advised that's not the way you do it. Her payments were refunded. She did not understand or get a clear instruction. Certainly, I haven't seen anything in writing that instructs her how to make that payment. And to that end, she had not made future payments because she wasn't aware of how to do it. Subsequently, she has some issues. She's currently unemployed. So garnishing a paycheck or things of this nature are going to be ineffective, for one, right now. And secondly, she has shown the court that she is willing to pay voluntarily. She would like to continue on a payment plan, certainly something that's affordable in a situation such as now where she's not employed. We're respectfully asking that the court allow her to continue a payment plan. Perhaps brother counsel can send something in writing as to how those payments should be made, and my client will follow through on that.
All right, have you and Mr. Collins talked about this prior to the hearing today?
Yes, Your Honor, Mr. Collis has no interest in my proposed resolution.
Mr. Collins?
Yes, Your Honor. Quite frankly, everything that Ms. Faringa just said is inaccurate on a number of different grounds. Let's start with procedurally. Procedurally, when there's a motion to set aside installment payments, there are 14 days in which the defendant has to respond. She did not respond in those 14 days, and it was automatically set aside. Secondly, so she has no basis for vacating anything on that. Secondly, we've been dealing with Ms. Cooper for a very long time. Ms. Cooper got, I believe this is her second order for installment payments, but it may be her first. I can't recall on that one about. Let's go back to history on this one. So the order for installment payments was entered on this case on September 17, 2021. She was supposed to pay $125 per month. On December 3rd, Ms. Cooper called our office and said she had been making payments online. My assistant Dustin said, you can't make payments online because that is for our clients. And she said, and then we talked to her about it, that she would make payments by check, money order, or cash. And she said that she would make up all the payments that were missed. This is on December 3 of 2021. On December 3, 2021, she called again and asked if we sent proof of the order installment payments to her employer. And we told her that the letter went out to her employer and we received a garnishment check after the payment plan was in the mail, and we mailed it back to her employer. So again, we're following the order. We're doing everything that's required. Then we hear nothing, absolutely nothing from Ms. Cooper until May 16, or May 12, when we get something from Ms. Faringa. So what we have here is a defendant, quite frankly, who knew already that she was supposed to do things by mail, said she was going to get caught up, did not get caught up, and we received on June 2 a garnishment payment of $557. I believe that was from her taxes, though. So Ms. Cooper, all this time, even during the pendency of this case and the pendency of this motion, still hasn't made a payment. So, Your Honor, not only are we asking that it be denied, we're asking for sanctions in this matter. Ms. Cooper, quite frankly, is in violation of MCR 1.109E. Quite frankly, I think her counsel is as well. And this, we've had what? I'm looking here in history. 1, 2, 3, 4, 5 different garnishments on Ms. Cooper. This case has been open since 2016. And now, according to her employer, she was terminated from employment on May 4, 2022. We are not interested in a payment plan with Ms. Cooper. And we would ask that you deny this motion for relief because, quite frankly, she's demonstrated absolutely nothing that requires this relief.
All right.
Real quick reply, Judge, if I may.
Let me back to you, Madam Counsel, in just a moment, Ms. Cooper. Mr. Collis, so the installment order was initiated in September of 2021.
Correct.
To be at $125 per month. How many of those payments was received?
We received 0 payments, and I can actually go through my history and see how many attempts she made. She made an attempt on September 17, an attempt on October 29, and she made no subsequent attempts to make payments. Those were the only 2 that she tried to submit through our electronic means on the website. There have been no other attempts.
All right, let me ask you
The reason I
about
know this is because I get an email or my office gets an email every time there's an attempt.
All right, so when you say that there is an attempt, was there in fact a payment submitted to that mechanism, or what? What do you mean when you say an attempt? Because I know you weren't allowing the payments, but was there some money submitted there, or what happened?
What happened is she went to our website, went to an area where we take payments for clients online. So for our retained clients, our hourly clients, whatever, we take payments online. She went there, submitted her credit card information, made a payment on, or tried to make a payment on those 2 dates, but because she was not a client, the payments were rejected. She talked to us on December 3.
All right, you told
And
me
we
about that.
informed her of this, and she never made a subsequent payment either by website or by mail.
You already told me about that part.
Yeah, I just wanted to make sure that it was, that we understood what was going on here.
Well, the big ears are indicative of the fact that I hear pretty well on these things. Thank you. I just needed to drill down.
No, I know, you've known me a very long time, Judge.
Yeah, got you, sir. All right, back to you, Ms. Cooper. I understand, as you've already indicated to me, that there was an attempt to stop the order from being set aside. But I want to drill down on what happened in this regard. So she attempted to make 2 payments, is what I'm getting, and those payments were not negotiated. And the council said that she was aware of and/or informed that she could make the payments via mail at any time. Go ahead and talk to me about it.
Certainly, Judge. So I find Mr. Collis's recitation akin to those in glass houses shouldn't throw stones. His response is quite disingenuous. He wants to allege that I'm making disingenuous statements to Your Honor, but literally he refuses to admit that it was in fact negotiated. They took her payment, they accepted her payment, and they refunded her payment. They had to refund the payment. So I'm real interested in Mr. Collis's language choices while addressing Your Honor. Aside from that fact, Judge, my client absolutely intended and tried to follow through on the September installment order by making a payment in September. She then made a payment in October. She did have difficulty with her payments, and when she could finally figure it out with an oral conversation, she by then had issues with her employment. I believe there were actually, that might have been a medical issue. I apologize, Judge. I don't have quite the details on that, but there were issues with her financing. And she did not understand how to make a payment. I defy Brother Counsel to send me the written instructions that he provided to my client for her to understand how to make payments, because obviously something was lost in translation. At the end of the day, my client had 14 days to object to his motion to set aside the installment payment order. She did. I've attached the time-stamped copy that shows on April 20th, Mr. Collis mailed out his motion. And on April 29th, 9 days, less than 14, my client filed her objection there too. Because of a paperwork error, clerk error, whatever it is, innocent error, the order setting aside the installment payment was entered without hearing. It's no big deal. We're here today asking that that order be set aside, and we have the actual hearing on the motion to set aside the installment payments, for which I would make the same arguments and say my client is trying and she's unemployed and would like the opportunity to pay by installment payment. That's all.
If the court takes the various things that have been set forth on this record, and I assume for the sake of argument that the order was entered without that there was a petition within the 14 days and that the order was entered without allowing a hearing on it. Assume for the sake of arguments that I set the order aside, my inclination would be to then grant the petition under the arguments that have been set forth here, setting the payment order aside. So I appreciate the candor that has been presented here. I get that, and I hate for lawyers to kind of go back and forth on some stuff about their truth, veracity, and honesty. Oftentimes, truth, honesty, and veracity dies on the anvil of a difference of opinion and the velocity of arguments that are being made here. I have not heard anything that smacks in any degree of untruthfulness. What seems to be intuitive here from everything that I have heard is that there's been a period of 10 months that have expired, and no payments have been accurately made. That's the crucial issue that is involved here. Is that you got 10 payments, 2 attempts, Those attempts, whether payments were accepted, at some point they were returned, whichever way, attorneys, if you want to argue about that stuff, you can argue about it. I tend to see with, I tend to see with single vision, so to speak. So the fact of the matter is that the ball drops where the ball is, and that is that in this case, this is a situation where there was a payment order, and that order required $125 a month, and for a number of reasons, there's been a lack of compliance. And I've heard Madam Counsel indicate to me that some of that compliance was secondary to the defendant not having resources at some point. And I also heard counsel for plaintiff pointing out that this is a 2016 case. So yeah, I get it. That there is a lot of going back and forth that is a part of this. I also heard that there was a garnishment with regard to state income tax that netted some $557. And counsel, let me ask you, Mr. Krause, would your agency have taken action as it relates to that non-periodic garnishment had the payments been made on a monthly basis?
I'm sorry, I didn't quite hear everything. Your microphone's soft.
Oh, I'm sorry. I got this big bombastic voice, and so I'm really disappointed when this equipment takes away that level of testosterone that's actually there. But anyway,
I miss seeing you in person too, Judge. I mean, how long you been on the bench? Because I've been in practice 26 years, so I know it's been a long time we've been together.
It'll be 30 years in October, believe it or not. I started when I was 14, but anyway, I got some other ones for you. But it'll be 30 years in October. I don't know how that happened. But the fact that my daughter is now a judge leads me to believe that it's actually been 30 years. But anyway, I wanted to know whether or not your agency would have proceeded with the garnishment of the income tax had the monthly payments been timely.
The answer is probably not. If she had been complying with the order, probably not. I mean, we're in the business of trying to keep people, making payments. We don't like to take extra work. We're only a small firm. I mean, at the time this judgment was entered, it was just me as an attorney and 2 paralegals, and now we're 3 attorneys and 3 paralegals. So we're not exactly big. We just don't have time to do extra work.
Thank you, sir. All right, my inclination here is, I mean, this is a critical failure of compliance with the order. That's what it comes to. I agree with counsel, Madam Counsel, that the order was probably entered in that loop where there is mail problems here. But if I set the order aside, my inclination under these facts would be to grant the order. So here's the position that the court takes on this, and I issue it by way of order. And I don't know what works best for the defendant in this matter, because of the fact that counsel has been forthcoming in that she is dealing with some work loss, loss of income, etc. But here is the order of the court. I will grant the motion to set aside the order setting aside the payment order, conditioned upon the payment of 5 payments that are in arrears. If she will pay the 5 payments, I will reinstate the partial payment order, and she can go forward with the order as it was previously entered. And again, the parties perhaps need to talk about exactly how that payment is to be made, if she's going to make it. Obviously, if she's going to make that payment and not going to make subsequent payments, then of course that's going to result in the order then being set aside once again. But I'll reinstate the partial payment order, conditioned upon the payment of 5 months in arrears at $125 a month. So that puts us at $625, or is it $625 if I'm counting correctly.
Judge, would we get credit for that garnishment of 5 something that Brother Counsel mentioned?
No credit for the garnishment.
Okay.
No credit for the garnishment. The garnishment is what it is. The garnishment will be applied, of course, against the balance on the judgment. But the payments would have to be separate from that.
Very good.
Your Honor, just some clarity, because I think I understand what you're saying, but I want to make sure. You said that there's 5 payments behind, but there's not been a payment made since the inception of this order in September, which is 9. So is it to catch up 9 payments? Or are you saying because the 557 was made that she's actually getting some sort of time extra, if you would?
Well, you saw my hand on this. I calculated that there were 10 payments behind.
Yeah.
And my intention is to allow, if she can catch up on 5 payments, that she would be able to get back on the payment order. And some of the consideration for the 5 other payments that were not made, some of the consideration is born out of the fact that there was a garnishment, a successful garnishment herein.
That's what I understood. That's what I've read you for 26 years, but I wanted to make sure I understood what was going on, because I'm old too now and I don't know everything anymore.
What do you mean? Oh, what do you mean all 2 now? Are you saying 2 as in also?
I'm saying 2 as in also being 53. So I know that you're only 54, but you know.
I'm taking exception with the old part, but anyway. I
When
will mention
I'm looking at my kids and they're now teenagers, I'm having a hard time. So I appreciate it.
well, I'm coming back to you, Madam Councilman. Looking at my kids now, I have 4 that are grown, and the youngest of the grown ones is 28, and then I have a 8-year-old and an 11-year-old. So I'm looking all different kinds of ways. So I was finished and I started all over. So 8 and 11 is where my boys are right now. All right, so that's my order in this case. I hope that can move things forward. And
let me ask one more question, if I may. You say the 625. When would that need to be paid by?
yeah, and that's what needs to be worked out. My inclination is to grant a 14-day period to resolve that.
Yeah.
I was going to put the 2 of you into a breakout room to kind of talk about that, or the 3 of you to kind of talk about how to drill down on that. But I'll grant 14 days to get that resolved. If it's not paid within 14 days, then the order will remain in place. That is the order setting aside the payment plan.
14 days is just fine. I do have a 10:30 to get to, so I appreciate your getting this case done before then.
All right.
Very good, Your Honor. We appreciate the court's ruling. We'll prepare an order and we'll get payments made.
Thank you. Thank you.
Thank
Good
you,
day
Your
to
Honor.
all of you. Bye-bye.
Thank you, Judge. Bye-bye.
This is case number 10-110313. This is Hirschberg Acceptance Corporation versus Yancy. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that this garnishment is regarding Highgate Hotels. The record should further reflect that the judgment was entered in this matter initially on the 21st of July 2010 for $1,212. That judgment was renewed in 2020, July 20th, 2020, for $1,212.43. And your appearance for Hirschberg, please. Hirschberg acceptance, please.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record P72322.
Thank you, Ms. Francis, and good morning to you. I'm looking now for Shanita Yancey or someone representing her. If you're on the Zoom, please say something at this time. Ms. Yancey, or any attorney for Ms. Yancey, if you're on the Zoom, please say something at this time. All right, the record should reflect the matter set on for 10 o'clock a.m. It's now 10:33. Doesn't appear that Ms. Yancey has appeared. Counsel, any information here?
Judge, we have been on similar objection to garnishment filings that Ms. Yancey has filed. We were here on May 25th, and then we were here again on June 8th, and now we are here again on June 29th. So she just keeps filing these objections. Then she does not appear for the hearing, it gets denied, and then she turns around and files a brand new one. This is the third time she's doing that, Your Honor. So at this point, I would ask for her objections to be denied with prejudice and for some costs, Judge.
I will certainly deny the objections at this time and allowing funds to be released to the plaintiff. Any further filing of motions will be subject to the assessment of cost. And I'm going to put that on the order so that Ms. Yancey is aware that any subsequent filings will be subject to assessment of cost.
Thank you, Judge.
Thank you, Counsel. Good day to you.
You too.
All right, the court now calls case number 19-155-900. This is Michigan First Credit Union versus Dallas Calhoun. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect in this matter that the court recently set aside the just one moment. The record should reflect that the judgment was entered in this matter, the entry date on the 23rd of September 2019. The judgment was for $8,942.56. Your appearance at this time for Michigan First, please.
Your Honor, good morning. Michael T. Mamet, P81102 on behalf of plaintiff.
Mr. Mamet, good morning to you. I'm looking now for Dallas Calhoun. If you're on the Zoom, please say something at this time.
Yes, good morning, Your Honor. This is Dallas Calhoun.
Thank you, Ms. Calhoun. Good morning to you, ma'am. So it looks like this is a garnishment against, apparently against wages at the Urban League. And it looks like the objection says the writ was not properly issued, otherwise is invalid. I was not served and I need to see the arbitration clause. All right. So, ma'am, it sounds like you're raising some issues to attack the underlying judgment. And if that is what you wish to do, you have to do that in a different type of motion. You can't do that in a post-judgment motion.
Okay.
So,
Okay.
See what you may have found in the past. But yeah, you can't object to the payment of the judgment by attacking the underlying judgment. The law doesn't allow you to do that. You have to file something saying that you believe that the judgment is not properly entered for some reason, and then those reasons could be examined. Anything else you wanted to tell me about this? You work for the Urban League?
Yes, I do. And I did speak to an attorney in regards to what you just said to me. So that's fine. I do work for Urban League. I am responsible for my payment on this. I was making payments prior to COVID and prior to a loss of a job. I was making payments. So I do want to continue to make the payments. I can't remember the time frame, but I tried to call because I had some help at the time where someone was going in my family was going to help me try and get back on track. And they told me since I wasn't working,
Yeah, you're
that I
breaking,
wasn't able to set up any payments. So I thought furnish me. So okay, can you hear me now? Because I'm at work. I'm outside in my car for privacy. Is that better?
I heard you say that you were trying to get the payments set back up, but because you weren't working at the time, you weren't, they wouldn't allow you to do that, something along those lines, correct?
Correct.
All right, I do see that a payment order was set aside back in November of 2020. At the time, it indicated that you were $500 behind on the partial payment order. That partial payment order looks like. All right. I think you see exactly when it was entered, but that's okay. Counsel, let me hear from you, sir, regarding this matter.
Good morning, Your Honor. Like you mentioned, it seems like she's trying to attack the underlying judgment, which is an improper way to go about an objection to garnishment. I'd ask that the objection be denied. And if she does wish to enter into a new payment plan, she has every right to contact my office and see if we can set something up. And if the court would like, and if she would like, we can even stipulate to a new payment order and submit it to the court. However, this morning, I'm not in a position to present an offer for an installment payment plan nor discuss one.
Got it. So how much is being garnished from your wages? You get paid twice a month, do you?
Yes, Your Honor, and that's the issue. Right now, they have an amount on hold. She said it was 25%. So I'm not sure how much. My only objection would be I only work 35 hours a week. I only get $2,000 a month. So of course with rent, car and gas and lights, I'm being stretched really thin. So I can get on a payment plan if I'm allowed. And I did try to call the office before I came to the courts to file. And the representative I spoke with said that I couldn't set up a payment plan, but I did attempt to try.
Right. So what you're being garnished is about $500 a month, correct?
Yes.
Yeah. So because you said you take home, you make about $2,000 a month, so that means that they will take $500 a month. Is that correct?
Correct.
All right, ma'am. All right. So
Yeah.
in this regard, ma'am, I have to find, as I will, the objections invalid. Any funds that are withheld will be released to the plaintiff to be applied towards the judgment. How much did you want to offer by way of a payment agreement that the court could potentially issue?
Okay, so after I pay all of my bills out of this small amount, I only have $350 left a month to live off of. That's for food, for gas, toiletries. That's all I have is $357. I was asking for time if you can release those, because like it's the first, I would not be able to pay my rent or anything. So I was asking just for time if you can give me the next pay period, or if they would let me do the next month, I can start paying maybe $125 a month. I don't even know how I'm going to do that, but I know I owe it, and I can try. I'll attempt to get caught up with that.
The problem here is that if I leave the garnishment in, then they're going to take $500 a month automatically. The law allows that. They don't take $500 from you a month. So here's what I'm going to do. I'll give you an opportunity to try to deal with this going forward. I'll set the payment at $150 and I'll require your first payment on this matter on the 15th of July. So the funds held be released, and I'll issue an installment order starting on July the 15th. That's when you have to make that first $150 payment. And the order that you're going to get from me is going to stop the garnishment. So they won't be taking any more money out of your check. In fact, what I'm going to do, just to make sure that I'll set your payment. I'm going to set your payment for the 22nd of July, July 22nd. That'll give time for the order stopping the garnishment to get in place with your employer. But starting July the 22nd, you've got to make a $150 payment and do that each month on the last Friday of the month. Or the order will end up being set aside and the garnishment will be put back in place. So this order will suspend the garnishment in light of the payment. If you make the payment, the garnishment stays suspended. If you don't make the payment, then the suspension will be lifted and the garnishment will continue. Right? So that's my order. You'll get two orders from me. One regarding garnishment, the other is a partial payment order, as I've indicated, and I do wish you well in that regard. Thank you, ma'am. Thank you.
Your Honor, just for clarity, the objection was denied and the funds will be released to the plaintiff.
Okay. Thank you.
Thank you, Your Honor.
All right, thank you. Thank you. Good day.
Have a good day.
All right, so ma'am, Ms. Coleman, you'll get something from me in the mail. You get two orders from me in the mail in the next couple of days.
So I'm sorry, I have one question, Your Honor.
Yeah, you're breaking up a little bit, so need you to.
Your Honor, I'm sorry. Could you hear me?
I can hear you now. Yes. I can hear you now, ma'am.
Okay, on the last part, I was confused. So the amount they have held, they're going to take that out of the check.
I'm releasing that to the plaintiff, and that is applied towards the judgment. Yes.
All right.
And then you have to start making partial payments in order to stop that garnishment. And your first partial payment is due on the 22nd of July.
Okay.
All right. I wish you well, ma'am.
All right.
All right, Mr. Kunine and Mr. Stratton.
Yes, Your Honor.
Welcome back. Sorry, you had to go through that whole other process there. All right, so update me, I think I sent you out to, well, update me where we are.
Your Honor, parties are close to settlement, but not quite there. We believe a trial date would motivate our clients to get that last little bit to settle. So we're requesting a trial date, please.
All right. So I will go ahead, I'll go ahead and do that and set it up for a trial date. Yeah, that's fine. This is the Baker College file, is that correct?
No, it's the Synchrony versus Deborah Brown.
3-2, ending in 332.
The last three are 332, Your Honor.
Okay, I have it down. Yes, sir. All right, so I'll go ahead and set a trial date, and hopefully that moves it towards resolution. If not, at least the parties will have a date certain that they can move forward. Madam Clerk, if you would, please.
How far?
Fairly close. We'll do somewhere within the next 45 days.
45 and then go to August, so we're something like August, what, like August 10th?
Yeah, let's go ahead. August 10th.
August 10th is good for plaintiff, Your Honor.
I'm fine with that, Judge.
All right, and that's going to be, I'm going to set that on for 10:30 a.m.
August 10th at 10:30.
Yes, sir. All right, you'll get a notice in the mail as well. All right, thank you, gentlemen. Good day to you.
Likewise,
Judge,
Your
if
Honor.
I may, Judge, if I may, if we resolve that, should we email that to you?
Yes, sir.
Mr. Canine, do you have the email?
I do, Your Honor. I believe your clerk's first name is Latifa. Is that correct?
That's correct, sir.
Yes, I have it saved in my email then.
All right, sounds good.
Okay, thank you, Your Honor. Thank you, Mr. Stratton.
Yep,
All right,
thank you,
good day,
Judge. Bye-bye.